Good morning, DMV. It's Dan Bouchard Fernandez with Remax Distinctive. Hope you're doing well today. We are talking today about fair housing in DC, particularly source of income housing, and how to avoid costly mistakes therein. Lessons learned are by others having paid the price for their mistakes so that you don't have to. Having some mistakes that others have recently experienced in the District of Columbia. There are 23 protected classes in DC, and that's something that's really important for us. However, there are only 20 that relate to housing. So of the ones that are related to housing, and by the way, you can find the links for all the documents that we're looking at today in the blue hyperlink that's at the top of the page. Race is defined by groupings of people that are in the population that come from demographics of a particular region of the world, and they are most commonly associated together by their physical appearance. Color has more to do with the varying tones of skin that we have in the various groups. Religion, we understand that pretty clearly, and that all religions are presumed to be equal. National origin, you might have people of a particular ethnic group that come from a specific nation state. So that might come from a specific nation state. And sometimes we see some nations in a geographically similar area that are opposed to each other. So there might be, nation X might not like people from the nation Y, and there's a lot of social disagreement between those parties. Sex obviously is very, very broadly defined to involve anything related to sex and gender. Age, we have the age range. We have some people who are slanted against youthful people who are slanted against the elderly, and we've got everything in between, right? So we've got discrimination based on millennials, some discrimination against Gen X or boomers or whatever. That all falls into the age appropriate category. Marital status, whether somebody's single, married, they're open relationships, or all of those categories. Personal appearance, whether somebody looks very well-to-do and very affluently dressed, it looks like their life indicates that they live on the streets. And varying degrees of bathing and the appearance of how clean or kept somebody is. So we can't discriminate against individuals based on the appearance that they have. So maybe it has to do with wearing a special cultural item on their clothing or on their body. Generally, we're talking about sexual orientation as between following on the spectrum of being straight or gay, and anything in between that. We have people who will dislike members of a spectrum position. They may be opposed to on a personal level for whatever reason. Gender identity. So this has come up in more recent times. Individuals not matching their psychological or mental identities. They may feel more comfortable identifying as a man or as a woman, or they may very well feel like they don't fit in their own bodies. It isn't something that is related to sex. It isn't something that is related to sexual orientation either. It has specific, unique distinction of being somebody that is of identification with their physiological condition. So it's important that we understand that it's not sexual orientation and it's not sex, but rather it has to do with where they fit in comfort with that and whether or not they feel comfortable in that identity. Family responsibilities. There are people who do not like the idea to have a household where there is perhaps two adults, responsibilities of caring for children, whether they're their own children, their adopted children, whether they are guardians of those children. And similarly, there are those individuals who have to care for elderly or perhaps disability challenged individuals. Political affiliation. On the political spectrum, we sit in various different positions along the political spectrum, and we have to make sure that we do not discriminate against those who differ from us in a political way. And just because somebody is of X party and I'm of Y party, must be blind to the political affiliation of individuals. Disability, recognizing disability, appreciating disability, and sometimes recognizing that disability may not be obvious. So those are things that are very critically important to us, and we've got to be able to articulate that and understand that discriminating against somebody and making assumptions about what they can and cannot do because of that disability is not our job. It is not our position to be able to say, well, this property isn't good for you because of your disability. We think it's not ideal for you. So therefore, you have to always give the person with the disability the option to choose. They always have to have the primary option to choose. We also have to give them the opportunity to make reasonable accommodations. There is a limit to that, and there are some further things that we can talk about if we dive into that disability classification a little bit more deeply. But for today's purpose, we're just going to leave it at that. Matriculation is the concept of having a formal education or not having a formal education and where you fit on that spectrum. So the amount of education that a person may or may not have is irrelevant in the course of our discussion. Familial status. So what kind of family status they have? What is the structure of that family? How many participants are in that family? What does it culturally look like? Those are things that we cannot be concerned with. We cannot identify that. We cannot define it for ourselves. Their familial status is acceptable to us. Place of residence or business. So where you live, what you do for a line of work has nothing to do with any kind of housing applications. So what you do as a line of work, even recently we can talk about the proliferation of marijuana sales. And there are some people who have strong objections to that. And there are some people who don't have objections to that and feel comfortable with that. And then the status as a victim of intrafamilial offense, spousal abuse, any kind of domestic kind of violence situations, and anything that has. And if somebody has brought it to our attention in their application process that they have been the victim of domestic abuse, we can't then go ahead and assume that they're going to be problematic as a tenant because of their history, and therefore deny them an application for that. So what does the law prohibit? It's an unlawful discriminatory practice to deny directly or indirectly any individuals the full and equal enjoyment of housing, including the rental of a dwelling, services, facilities, and privileges based on the source of income. If we're going to make a property accessible for one group of individuals, we have to make it accessible to all groups of individuals. If we're going to allow showings of properties for one group, we have to allow it for all groups. We have to impose all of the same terms and conditions in the one group that we prefer and apply it to any group that we don't prefer. Everything has to be equal. Everything has to be on the same terms across the board without any variations, no change in terms, and no change, no desire to code word some definitions of things and to say, well, this might not be the best place for you because XYZ. HRA, the Human Rights Act of Washington, D.C., defines source of income as the point, the cause, or the form of the origination or transmittal of gains, money, of property accruing to a person in a stated period of time, including but not limited to money and property secured from any occupation, profession, or activity, from any contract, agreement, or settlement, from federal payments, court-ordered payments, from payments received as gifts, bequests, annuities, life insurance policies, and compensation for illness or injury, except in a case where conflict of interest may exist. So in short, what this really means, money from any legal source, as long as the source of the funds is legal and amounts to being qualified to pay the rent on time, then that's what we have to accept. In the event somebody wants to file a complaint against you, it's going to be the Office of Human Rights that brings the charge against you. And they will attempt to mediate any charge that is brought against you. And that the complainant may be represented by an attorney or may not be represented by an attorney. They interpret the definition to include monetary assistance provided to an owner of a housing accommodation, either directly or through the tenant. Discrimination based on one's source of income can include, but is not limited to, payments from federal or local programs, short and long-term rental subsidies, housing choice vouchers, Section 8, emergency assistance payments, Social Security supplemental security income, unemployment insurance payments, alimony, veterans benefits, disability benefits payments. So normally the first 5 of these categories are the normal ones that we often think about when we think of source of income. But another one is the unemployment insurance payments. So a prospective tenant who is unemployed and has the ability to demonstrate income, including their government or private compensation for housing, we must include that, and we cannot discriminate against people solely because they are unemployed. We can't discriminate against them if they're receiving alimony, child support from the Veterans Administration, and if they're receiving disability from another source. Some examples of federal and local subsidy programs include, but are not limited to, housing choice vouchers, rapid rehousing, emergency rental assistance, permanent supportive housing, based rental housing under the Housing Opportunities for Persons with HIV. So understand that there's a couple of factors here that fall into this. HIV is not a disease that can be acquired by any kind of social contact whatsoever. It is not a disease that is any risk to anybody that lives nearby. It's not something that can be passed on by touch. With medication, the individual with HIV becomes undetectable and therefore becomes immune from being able to pass the virus on to others. Even in sexual contact, they are undetectable, and that means that they are unable to pass the virus on to others, even with unprotected sex. So having any kind of discrimination against anybody who you happen to know has HIV is completely illegal and is not allowed to be discriminated against in any way, shape, or form. Short-term rent, mortgage, and utility payments. There are some programs that are there to help individuals with those short-term shortfalls in income. Veterans Affairs supportive housing, special category of VA benefits, shelter plus care, and those are some other things. So just keep in mind that all of these things play into the source of income dynamic, and we have to be able to make sure that we are not exercising any discriminatory practices based on these. If somebody approaches you and asks, will you accept financial assistance voucher for this property? Keep in mind, will you accept financial assistance voucher for this property? The answer is always yes, absolutely yes. Without any wavering, it must be yes. A lot of times, the way that discrimination complaints are filed is because somebody deviated away from the answer on this. If I have a listing today on 123 Main Street, and I have an applicant that comes back to me and says, will you accept financial assistance voucher on this property? And I answer anything other than yes, absolutely yes, I may have very well put myself into a position of, regardless if it's a tester or not, it could be an actual tenant or it could be a tester. The fact of the matter is, it really doesn't matter if it's a tester or not. Putting yourself in the position and stating, even flippantly or casually or without even thinking about it, you have to really put this in the frame of mind of answering this question definitively, explicitly, clearly, to articulate that yes, absolutely yes, we are willing to work with housing assistance provisions and vouchers. No questions about it. The only acceptable answer is yes, absolutely yes. Deviating away from that, qualifying it and saying, well, accept that, or maybe this is better, or anything, any kind of qualification that way is completely unacceptable. This is where agents get nailed with complaints a lot of times. So just be aware of that, and please make sure that you understand that you can't answer anything else other than yes, absolutely yes. All right, some examples. If you look at the link again at the top of the page, we see a bunch of examples. So let's go through some of them. A building owner or representative, such as a property manager or superintendent, or maybe it's a listing agent, refuses to accept Housing Choice Voucher Section 8 toward the tenant's rent payments. An applicant calls a housing provider to inquire about the availability of a 2-bedroom unit. The housing provider states that the unit is still available and the rent is $1,700. The applicant asks, does the housing provider accept Housing Choice Vouchers? The housing provider asks a number of questions. Eventually, the housing provider tells the potential applicant that they don't use Housing Choice Vouchers. This type of refusal may, and I can guarantee you will, be a source of income violation under the Human Rights Act, because the housing provider has refused to consider the applicant's housing voucher. We cannot make that determination or distinction. The tenant has to make the decision not to go ahead and pursue our specific property. We cannot make that decision for them. So some examples of inquiries and comments that may be evidence of discrimination. If you say any of these things, I can guarantee you, you're probably going to get a complaint filed against you, and the defense of that complaint will be extremely costly to you. We don't take people on SSI, that's Social Security. 2 years steady employment required. We can't qualify them based on whether or not they have a job. That is totally irrelevant. The income is what's required, not the employment. Each roommate has to make 3 times the rent. So putting inordinate conditions on the prospective tenants in order to compensate for that is something that we cannot do. As long as we have the cumulative total of the tenants having the income, the combined total of the tenants having the income, that's acceptable. If we make any requirements for each of them to qualify individually, that's where it becomes a problem. We can't do that. I've found that people on Section 8 don't fit in well here. That's code for, no, we don't want to do that, and that's a violation. Even if you have a Housing Choice Voucher Section 8, you must make 3 times the full rent. In a Section 8, in any kind of financial assistance, if the entire amount is covered in that financial assistance by the third party, whether it's the government in some fashion, or a nonprofit charity, or another organization, or another individual, if the entire amount is covered, we cannot deny their application based on that. So if you've got a situation where a parent is paying for the student to live in the property, then we cannot deny that situation. That's a discriminatory act that we cannot, and that could be considered matriculation discrimination as well. So we cannot make a distinction on by giving them the ability to qualify for the rent if somebody else is paying for it, particularly if it's educational based, then that's matriculation. Don't bother applying if you don't have a job. We can't say any of these things on this list or anything similar to this. Make sure that we don't abridge that. All right, other policies or practices which may constitute source of income discrimination. Denying a rental application because of the applicant's partner's or family member's lawful source of income. As long as it's a legal source of income, it doesn't matter what it is, we have to accept it. Asking whether the applicant is receiving any government assistance or Social Security, and then denying the application. So, you know, asking them, you've got to be very, very careful about making questions about they're receiving any kind of governmental assistance or Social Security. I would, as a matter of company policy, I would suggest that we don't even ask this question at all. Simply asking the question may very well put us in a complaint situation that we would then have to defend. And usually in the Office of Human Rights complaint system, we are deemed to be guilty until proven innocent. And if you make a statement like this, you're automatically guilty of violating the source of income provision. Advertising apartments with the phrase "no programs" or "no Section 8 included," no can do. We cannot do this. This is a very bad precedent to set. We cannot advertise. We cannot articulate it in our voice. We cannot say it face to face, in a text, in an email, and an advertisement, in Bright MLS, in the agent remarks or in the public remarks. We cannot make these kinds of statements whatsoever. Similarly, the same principle applies if you're trying to say we won't accept VA loans or FHA loans, and you're putting that in the MLS. That's a violation, and that violation exists also in Maryland. If you haven't heard that also, so that we cannot put the acceptable types of loans in listings in Maryland and DC. Don't put that in there in your listing, because that will be automatically a flag against a preference for that kind of the source of funds, source of income. Stating that the Human Rights Act only applies to new Section 8 voucher holders and not existing tenants. So if somebody's already a tenant and then they become eligible to receive vouchers, you can't deny them their rent simply because now they're on a housing voucher. You have to accept them. If they were accepted before and then they become eligible and do start to pay their rent via some kind of financial assistance, we have to continue serving them as the landlord, and as long as they're continuing in their lease legally, then we cannot discriminate against them. All right, so some best practices. Housing providers do have a right to set financial and credit qualifications. So we do have the ability to go ahead and say that we have to have a certain amount of income and a certain amount of and a certain kind of profile of credit qualifications. And if you follow one of my other courses that I teach for DC in this respect, you'll understand that there's a whole list of things that we are required to state up front to tenants that are what will be acceptable for an application and what will not be acceptable for an application, and what's the basis of those factors that are identified there, and making sure that they qualify in order to be acceptable for a lease. So we have to make those declarations in the beginning of a lease before it starts and before being accepted. And so housing providers do have a right to have certain expectations, so long as it doesn't infringe on the source of income protection. A process that provides some assurance that the applicant will be a good tenant. So we're looking to see, a lot of times, a lot of tenants have objection to us looking at their credit reports, claiming that, well, that just because I have a bad credit report doesn't mean I will be a bad tenant. Well, objectively, that doesn't hold water, and landlords do have a right to look at the credit overall and to see how responsible that individual is. But you have to look at the entirety of their credit file and understand the history. And when you understand the history of it and determine from it, not based on any sole particular item in their credit file, but look at the patterns and how recent those negative inquiries have been. So all of the judgments that we're going to make on whether to accept an applicant or deny an applicant must be equally applied, regardless if they have financial assistance or they don't have financial assistance. Whatever qualifying screening criteria a landlord uses, he or she should apply them equally to all participants. When the landlord, broker, owner screens a tenant during the application process, the landlord should carefully distinguish between legitimate questions about a tenant and discriminatory ones that violate fair housing law. So we can't ask the discriminatory questions. If you've got questions about those, please contact me and let's flush that out in a good, healthy conversation, and so that we can get you on the right path to not approach that level of scrutiny and potential violation of the Fair Housing Act. It generally prohibits housing providers from asking direct or indirect questions. So you can't ask a leading question that may reveal a person's protected class. You can't ask vague, ambiguous questions with the expectation that the tenant is going to respond and volunteer some information that discloses to you their actual protected class. If they happen to tell you voluntarily that information, that's fine. But if you have issued leading questions to kind of hear if they volunteer it, that's a violation. So wrapping that up, those are protected class situations. Inquiries designed to qualify a person are permissible. So qualifying them of what their rental history is like, qualifying them on their finances, qualifying them on their credit, as long as it's not a credit score. We can't make determinations based on the credit score, but we can look at the entire package. Then we're good to go. All right, again, the link at the top of the page brings us to this page right here. And we are diving into the source of income discrimination in housing. Under the DCHRA, the DC Human Rights Act, it is unlawful to deny directly or indirectly any individual the full and equal enjoyment of housing, including the rental of a dwelling, services, facilities, privileges based on a person's source of income. The Eviction Record Sealing Authority and Fairness in Renting Act of 2022 updated the protections under the DCHRA regarding source of income by adding the following. And keep in mind, I teach a course specifically on this for GCAR. So if you want to get more deeply involved in this, we can talk about this in the separate course. And it really hits home to some of these new protections that have been started as of 2022. Prohibiting discrimination based on past credit issues or rental payment history that occurred before a prospective tenant received housing subsidy. So if they now receive a housing subsidy benefit to pay for their housing, but prior they had credit issues, they were all over the map, we can't use that bad history. If they've got a housing certificate now, we can't use that bad history in the beforehand against them. If they're having this subsidy now, we've got to base it on what that is and what their current subsidy is. Prohibiting discrimination based on income level and credit scores unless required by law. Well, by federal law. I'll tell you that that in most cases there are no federal laws that allow you to do that. So the DC law takes precedence here because of that. Creating a rebuttable presumption of discrimination if a housing provider charges any fees, deposits, or additional rent on individuals using income-based housing subsidies, which they wouldn't impose on those not using those subsidies. If you're going to apply it in a fully eligible applicant that is not using special benefits, you must include it and make those same kinds of conditions applicable to the tenant who does have subsidies or any kind of source of income qualifications. Got to apply everything equally. A prospective tenant visits the leasing office of a housing provider to inquire about the availability of a 2-bedroom unit after hearing from an acquaintance that the housing provider has good 2-bedroom units and that all those units cost only $1,700 a month. The prospective applicant asks whether the housing provider accepts housing choice vouchers, and the housing provider acknowledges that it is required by law to do so. The housing provider then tells the potential applicant that the rent for the relevant unit is $2,000. So the original quote for the price for the rent was $1,700, and now they're saying it's $2,000. If the applicant's acquaintance who quoted the $1,700 a month provided accurate information, there is a rebuttable presumption of discrimination against the applicant under the DCHRA based on the applicant's source of income, unless the housing provider can provide evidence showing that no discrimination occurred. For instance, documentation of a price increase that took effect following the prospective applicant's conversation with his acquaintance. Again, keep in mind, you've got the burden of proof is on you to defend yourself. In the Office of Human Rights hearings that are held and the mediation process that goes through there, the obligation of defense is on yourself to disprove the situation. I'm not saying I agree with that approach. I don't necessarily agree with that, but it is the process that's in place, and it has been challenged by courts, and it has been upheld by the courts. So understand the burden of defense is on us if we are presented with a claim of discrimination, and we will then have to defend ourselves. And if you can't negotiate an acceptable amount of money to pay to the complainant, then it'll go to the Real Estate Commission, and it'll go to further hearings, and it could go into active litigation in a court. So we want to avoid that whenever possible. And so mediating it and getting ourselves ahead of it early is the best scenario. Here's another example. A prospective renter seeking to rent with the assistance of an income-based housing subsidy applies for a one-bedroom apartment. The prospective renter lists his income as $25,000 per year on the application and notes that he will be using a housing choice voucher. The housing provider denies the application, stating that the prospective renter's income is well below the minimum income that it requires for the $1,550 per month unit. This refusal may be a source of income violation under the HRA because the housing provider may not require that a prospective renter show minimum income when the renter has an income-based housing subsidy. In the presence of a subsidy that covers the entire amount of the rent, we can't require further income above that in order to justify the application. We have to accept the voucher or the assistance as it exists if it covers the entire amount of the rent. Additional examples of inquiries and comments that may be evidence of discrimination. Again, we don't take SSI, 2 years of steady employment required. I found the people on Section 8 don't fit in here well. We don't give home loans unless you're fully employed. Even if you have a housing voucher, Section 8, you must make 3 times the full rent. Don't bother applying if you don't have a job. Again, we covered those in a few minutes ago, and we can't use those kinds of statements. Denying a rental application because of the applicant partner's or family member's lawful source of income. We talked about that a few minutes ago as well. Asking whether the applicant is receiving any governmental assistance or Social Security. We talked about that a few minutes ago. Advertising apartments with phrases. So what you say in public, what you advertise in public, what you promote in your flyers, what you say in email, text, Facebook, social media in general, phone calls, voicemails, anything that you say can and will be used against you. So don't make statements that you're not willing to accept housing vouchers. Don't even imply it. Don't even make innuendo about it. Don't even go close to it, because if you approach that gray line, you're probably going to be held in violation, and it will cause a suit that will end up costing you money. I can probably almost always guarantee it. Stating that the DCHRA doesn't apply to rent-controlled units, even though they were living in there when the law went into effect. We can't make any statements to that effect. Stating that the DCHRA only applies to new Section 8 vouchers, we can't make that statement. applying minimum income or minimum credits requirements to an applicant receiving an income-based housing subsidy. Can't do that either. And denying a rental application due to the applicant's history of non-payment or late payment with knowledge that the non-payment or late payment occurred prior to the applicant receiving the income-based housing subsidy. So regardless of their history, of their rental history, late payments or other things like that, it cannot use that as a reason to deny them their applications if they're now using the housing voucher. If the housing voucher is covered fully by the rent, by the amount indicated there, so be it. Great. You're allowed to accept them, and we must accept them for that rental. All right. Finally, in closing, will you accept financial assistance vouchers for this property? When that question is posed to us, the absolute and only response is yes, absolutely yes. No other answers are acceptable. If you got questions, feel free to give me a call, 202-309-2339, or D Bouchard, BOUCHARD, at remaxdistinctive.com. Thanks, and have a great day.